Am I audible to all of you? So I have a little fever today, so won't be able to respond much. Don't worry. I hope something will get in. That's what is needed. You don't need to respond much. Am I audible to all of you?
Yes, sir.
Good evening. Nice, sir. Last class we had some discussion regarding the starting of these two cases. Sorry, the state of Punjab was Davinder Singh. Any query as of now from the last class itself? Any query from the last class itself? Any query, guys? Any query? Any query from the last class itself? Everybody understood everything in the last class? Pranjali, Rajat, Rishabh, Srija, Sayok, everybody understood? Everything? Any question that you people want to ask? Anything? Vaishnavi, Kirti, nothing? Everybody understood everything? So what I can take? Shall I move forward to the Ivichinaya case? Right? Right, guys? Yes or no? Just give me yes or no. Shall I move forward or not? Achha, that's great. Chalo. So, in the last class, we talked about the conflict. Okay. We talked about what basically happened in relation to subclassification. So, just to give you brief context of what we were discussing in the last class is that from exception to classification to subclassification. Right, guys? Yes or no? So we understood 16.4 is an exception pre-1970. Then classification post-1970, Indrasani, facet another facet of equality. Okay. Now, this subclassification part, okay, this one of the very interesting thing that you need to understand. This subclassification, before I getting into the E.V. Chinaya case and also the Davinder Singh 5-judge bench case, okay, this subclassification has a history altogether. And today, as you knew that I was talking about this subclassification in the last portion or dying end of the yesterday's class, in which I was I was telling all of you that this sub classification, how the sub classification is emerged, because there's a concept of creamy layer, there is a concept of one group of people who are getting the most benefit, and states and other people were started to look at it, okay, started to feel okay, why one particular group of people are getting the benefit, though they don't need it, they don't need the reservation, they don't need the SC/ST tag, but they are getting it, and they are basically, with that help, they are misusing, okay. So because of this situation, because of this understanding that was going on, okay, and this going on for the last 20-30 years, it's not about 1 year 2 years phenomenon, okay, this sub classification emerged, okay. Now this sub classification, okay, it's not that for the very first time emerged in the EV Chennaiya, it's not like that, or it's not that like that sub classification has happened in Davinder Singh in 2020, ऐसा नहीं है. Sub classification has a history too, okay. Sub classification has a history too, and I'm going to write the sub classification history first, okay. I'm going to draw a chart, and then you people will basically, I'll explain that chart, because that chart will come down the time when we're going to read 5 judge and also 7 judge bench. So there is a sub classification history also, so I'm going to write that history. Why I'm deleting this? Sub classification, in sub classification, one of the first thing that was seen is, it is not that for the very first time it emerged in EV Chennaiya, okay. Sub classification first talked about in one of the case, that case you don't need to remember, okay. That case is K Basant Kumar case. It's a very important case in relation to other aspect of reservation. But in K Basant Kumar case, for the very first time, O Chinappa Reddy, probably double N hai ye, I don't know. O Chinappa Reddy, do check the, at least to check the spelling, okay. This is O Chinappa Reddy, for the very first time in the obiter, I'm talking about in the obiter itself, mentioned about the sub classification. Don't draw anything right now. Mentioned about the sub classification, and he stated, if sub classification can be done, it is for the betterment of the people itself. I'm talking about around 1985, guys. It's a sub classification history, okay. So case Basant Kumar case is the first case, and before that in MR Balaji some of the portion was there, but K Basant Kumar, where O Chinappa Reddy explicitly mentioned, and you will find, if you open K Basant Kumar case, there are 2-3 pages written about the sub classification, why sub classification is a very important thing, and अगर sub classification किया जाता है, if any sub classification can be done, how that will help in relation to this particular aspect, okay. Now after K Basant Kumar, Indra Sahani, okay. Indra Sahani case, talked about the sub classification, but here sub classification has been talked by a very different way. How? Again, it's an obiter, and some of the judges stated in the ratio as well, sub classification can be done for other backward class, mind it. not for SC/ST. So in Indra Sahni case, sub-classification was talked about. It was mentioned by various judges. But they stated sub-classification can be done for other backward class, not for SC/ST. Why? Why SC/ST were basically segregated from the sub-classification in 1992 during the Indra Sahni? It's because that one very important concept and understanding that was there, SC/ST were the most disadvantaged group and they're underprivileged. And now it is not needed or it cannot be seen in any kind of creamy layer from that SC/ST in 1992. So all the people belonging to SC/ST, without any iota of doubt, they deserve the full reservation. And in Indra Sahani, I hope many of you can remember, because today's topic is not about Indra Sahani. Creamy layer concept was there for Indra Sahani, but creamy layer is for whom? For other backward class. Mind it. Creamy layer for other backward class, that's where the main game that has been played. Because Indra Sahani, if you remember Indra Sahani case was one of the aftermath of a protest. Aftermath of a protest, which is basically, once again, kindly mute anybody. Second. Venkat, kindly mute yourself. I'm not able to mute. Yeah. Yeah. Thank you. So,
Sir,
sub-classification. Simran, do you want to say anything?
yes, sir. I was saying that can you please repeat what you said about Indra Sahni right now?
I'm going to. So in the Indra Sahni, one of the very important thing, Indra Sahni is a case, is the aftermath of a protest. Why? When the Mandal Commission report came into the picture, and in the Mandal Commission report, it was seen that there are so many other backward classes other than the SC/ST who are also disadvantages position. So various states started giving the reservation to other backward class, and that reservation is not merely 10-20%, it is like 27% reservation given to other backward class. And whatever happened recently for Bangladesh, okay, it has happened in India too in relation to reservation. When the Mandal Commission report, yeah, Venkat, do you say anything? Do you want to say anything? Achha. So whatever happened recently that led to the Sheikh Hasina's current fate, that happened in 1990 in relation to reservation in India as well. Because Mandal Commission basically stated there are other backward class, and that other backward class, because of that, states were giving reservation to other backward class, and the reservation is 27%. 15, 7.5, 27. It is like 49, 50% reservation for the very first time coming into the picture. It is similar situation, and that's there are so many protests going on. And that's why Indra Sahni, the two things in Indra Sahni that has happened, and they did, there are so many other factors that are there. 50% cap is there. Sub-classification can be. So they said the sub-classification can be done for other backward class. You can also be segregated from the other backward class. The people who don't need reservation, they should not be provided with the reservation. So other Indra Sani is one of the things, one of the case where sub-classification were stated by the Supreme Court. So first is Indra Sani. Okay. Achha. Now the next very important case regarding the sub-classification came into the picture.
Sir, can you
Yes.
please repeat that K. Vasant Kumar case once?
K. Basant Kumar case, I haven't told anything. I told it's an obiter. For the very first time, Obi Chinappa talked about this thing. Sub-classification can be done. I haven't
Oh,
stated
okay,
anything
okay.
about K. Basant Kumar because it's not needed at all.
Okay, sir.
E.V. Chinaya is not, I is there probably. Yeah. E.V. Chinaya versus State of Andhra Pradesh. फिर भी एक बार स्पेलिंग देख लेना इसका. Now, E.V. Chinaya versus State of Andhra Pradesh, this case for the very first time, the Supreme Court five-judge bench outrightly rejected the sub-classification. We'll find out the reason today itself. But for the very first time, set aside the sub-classification itself in the reservation.
For
Okay.
OBCs,
Mhm.
for OBCs,
For SC/STs specifically, because
oh,
this case is related to SC/ST. Nothing about OBC. This case is not about OBC at all. It is around 2004, something. Yeah. And this case, subclassification, nothing about OBC is mentioned. Nothing about this case is the legislation is all about the SC/ST. No OBC is mentioned. Then came the next part. Yeah. They mentioned the High Court one. High Court is not needed though. Here, one thing happened, that is Davinder Singh was the state of Punjab. There is Punjab Haryana High Court. Followed the same path. State of Punjab versus Davinder Singh now. Five-judge bench. This case is around 2010, if I'm not wrong. Huh? Around 2010. This is 2020. बीच में एक थर्ड जज बेंच रेफर करता है इस पर्टिकुलर केस को. स्टेट ऑफ पंजाब वर्सेस दविंदर सिंह. they logically interpreted sub-classification is pretty much possible. Upheld the Punjab, this particular, upheld the Punjab Act also. And refer the E.V. Chinaya to the larger bench, because E.V. Chinaya was 5-judge bench and this was also 5-judge bench. Tell me, Srijay.
Classification and
Hmm.
what?
You want
Can
to
you
say
please
anything?
read what you have written? That
Or
logically interpreted subclassification possible.
is
That state
possible?
of
Yeah,
Punjab
yeah.
versus the. And what was after that?
Also upheld the Punjab Act, Punjab Reservation Act, that was declared unconstitutional in this particular High Court.
And sir, that referred the Ivichanaya to what?
Larger bench. State of Punjab was Davinder Singh, 7-judge.
So the 5 judgments was of the Supreme Court or High Court?
No, 5 years Supreme Court, definitely.
Okay.
सब क्लासिफिकेशन इज वैलिड which has been recently अब कुछ दिन पहले जजमेंट आया इसका, ठीक है. Now this is the whole thing about your sub classification. Is there any query in the sub classification history? Is there any query? Is there any query in the sub classification history? Is there any query? Is it understood? This diagram we are going to talk about, okay, because this diagram is needed. But I hope everybody is done with the diagram on their notebook. Done?
Yes.
Yes, the E.V. Chinaya judgment was referred to larger bench. This one. Refer the E.V. Chinaya to larger bench. 7-judge bench अभी decide किया just recently. जो आप पढ़ने वाले हो आप लोग.
Sir, the larger bench means 7-judge bench.
Yeah.
Here.
Yeah. Is it done? Shall I move to the next part now? E.V. Chinaya now.
Yes, sir.
Everybody understood? कुछ query है? Rishabh, Rajat, Pranjali, Ronojoy. Probably is your first class. Okay. I hope you are able to understand, Ronojoy. Is there any
Yes, sir.
problem that you're facing?
No, sir.
If you face anything, probably regarding the sub classification, if you face, do ask me the questions here.
Okay.
Rishabh, getting it?
Yes, sir.
Rajat,
Yes, sir.
Rajat, yes or no? जा रहा है ना अंदर?
Yes,
You're
sir.
not there in the last class.
Yes, sir.
अच्छा. Venkat, are you getting it? Vaishnavi?
Yes, sir.
चलो बहुत बढ़िया. Now get to the next part. That is EV Chinaya. Now Basant Kumar and Indra Sahni, both are the thing. Both judgments will play huge role in EV Chinaya. And when you're going to see how the EV Chinaya was interpreted and how the Davinder Singh interpreted, with both the precedent, Indra Sahni and Basant Kumar were treated differently in both the cases. Okay. And you'll be able to understand that how sub-classification given a major role in Davinder Singh, where the EV Chinaya failed to do that. Okay. Now let's talk about this very important part like EV Chinaya. Because EV Chinaya is the case that you have to understand first. Because EV Chinaya in that particular case, the classification, sub-classification as a major issue came to the Supreme Court. Okay, and Supreme Court decided negatively. Now let's understand the EV Chinaya. Shall I delete this particular image? Everybody, shall I delete it? Or is anybody needed to draw this? I hope everybody has drawn it, right? Shall I delete this? Right? Delete कर दिया मैंने तो फिर चलो. Are you people drawing these particular things? Because last class I have also drawn something. ठीक है, आज भी draw किया मैंने. ठीक है. I hope
Yes.
you are just yeah. Anybody wants to say anything?
No, sir. I was saying yes.
So so I hope you are just drawing those things, because these things will help you to go through the things very, very fast when you need it. State of Punjab versus Davinder Singh se pehle, before State of Punjab versus Davinder Singh happened, we got EV Chinaya. Now, EV Chinaya was a very interesting case itself. Okay. And in EV Chinaya, whatever the things happened, you will get to see all the opposite thing in the Davinder Singh. Okay. So let's understand the facts of EV Chinaya first. Okay. And then we are going to get to the next fact of Davinder Singh. So EV Chinaya, what is this case all about? This case is all about an act, Andhra Pradesh Reservation, SC/ST Reservation Act. Okay. Andhra Pradesh SC/ST Act, Rationalization of Reservation Act, basically 2000, that was come under the scrutiny of Supreme Court here in relation to this particular case. Now, this act is quite interesting act. Why interesting? Andhra Pradesh, state of Andhra Pradesh, before passing this act, they set up a committee. Okay. And before passing this act, they set up a committee for one reason. Okay. That is to analyze the data in relation to SC. Okay, what is the situation in the state? So they set up a committee, and when the committee passed their report, the state of Andhra Pradesh, they saw there are certain categories. There are total 57 categories that is there in SC. I was showing to you last day categories of SC list, ST list. I was showing to you, right?
Yes, sir, yes.
Right. So in that SC, in the SC list in the 2000, state of Andhra Pradesh found there are 57 categories that are there in total SC list. Out of those 57 categories, what they did, they basically subclassified those 57 categories into the 4 categories: A, B, C, D. "57 categories of SC list, the tribes, caste, all those things, they basically merged as per the data that who is better well off, who needed the reservation most, who don't need the reservation, what is their educational qualification, how they are doing, how they're performing socially, educationally, in all those parameters they checked it. And based on that, they basically subcategorize these 57 categories into 4 subcategories. One is called A, another is called B, and another called C, another called D. Okay. Now, what basically happened after that? They passed an ordinance. In their ordinance, they basically 15% SC reservation divided into these 4 categories like this. Like एक मिनट में देख लेता हूँ B और C 760 होगा, I hope so. B C 760, no problem, okay. Because it's highly data based. That's it. Okay. Now, based on this, another thing to remember in Ivichne, because this is a very important case for you to remember. This particular ordinance, that was the report that they got it. There is Ramachandra Raju report based on that. Because you never know, for CLAT anything can be asked. So they basically created these 4 different kind of categories. Then whenever the assembly reopened, they passed that ordinance, made an act, and that act becomes Andhra Pradesh SC Rationalization of Reservation Act 2000. Okay. And
Sir,
this
can you please repeat about that ordinance part again, please?
ordinance part is nothing. First, they come up with the ordinance regarding this particular thing, and then when the assembly reopens, they pass that ordinance and make it a act. That's what happens.
Oh, okay. And the percentages are about the reservation provided to these classes.
Yeah, the 57 categories of SC, A, B, C, D. That's all. Okay.
This Ramachandra Raju committee report, what is that?
Ramachandra Raju commission report. Based on
Commission
that,
report?
they divided, subclassified this particular 4 groups, 57 categories.
Okay.
Okay. So I just mentioned it's too detailed, but you never know. Ivichinaya is an important case for you people. Okay. Now, this act is basically came for challenge because of one very important thing. First, under Article 341, what I showed in the last class, state doesn't have the power to subclassify, which state did. First. Second, whether the state have the legislative competence to pass this act or not. Third issue, whether the subclassification is actually violative of Article 14 or not. These are the three issues that were the main thing in relation to EV Chinaya. First is whether this particular act is violative of Article 341. Second, whether there is any legislative competence of the state to come up with this act or not. And the third, whether the state is basically whether this particular subclassification is violative of Article 14 or not. So far, whatever I have communicated, everybody understood. Did you understand the facts? Did you understand the facts of EV Chinaya? Everybody? Did you understand the facts of EV Chinaya? Anybody who hasn't understood? Anybody who hasn't understood, shall I tell it again? Understood ना? हाँ ना, कुछ नहीं आ रहा है. Got it?
Sir, can you please repeat the issues again?
अच्छा. The first issue that is definitely related to Article 341, whether it is violative of Article 341 or not. I'll just make sure to make you understand the issue once again. Legislative competence of the state. And the third is violative of Article 14. Now open Article 341 once. Open Article 341 once. Open Article 341. Open. Though I was showing this to you in the last class, but I want all of you to open once. Yeah.
Yes, sir, open.
Everybody done? Article 341. Is it done? I
Yes.
mentioned some of the part in the last class, and I need to tell that thing today itself. One second. Just read it once, Article 341. I am just opening it on Google so that I can share with you. Now, if you open Article 341 regarding the scheduled caste I'm talking about, and I was showing it to you yesterday also. President may, with respect to any state or union territory where it is a state, after the consultation with the governor thereof, by public notification specify the caste, race or tribes, parts or groups within the caste, race, tribes and everything. Okay. Shall the purpose of the constitution be deemed to be scheduled caste. Now, basically, president will create that list of what I have shown. That is, what was the site? Social. Yeah, this is the list for Punjab. You can see it. Can you see? It is the Punjab list, everybody. Everybody can see it.
Yes, sir.
What I was showing to you yesterday also, but many of you. This is a kind of list that is created by the president under Article 341, and each state has this kind of list. Okay. Now, president has the power to come up with this list. Now, in any kind of tinkering with this list, tinkering in the sense any kind of addition or deletion that can be done in relation to this, that power is vested with the parliament under 341(2), right guys? And it is pretty much vivid and crystal clear from the 341. Here under Article 341, state doesn't have any power at all. What state has is just in relation to 341, nothing but to agree with what president has issued the list, and any kind of chopping or changing that needed to be done in relation to that list, that will be done by the parliament. Getting it? Is it clear? Is it clear?
Yes,
Yes,
sir.
sir.
Everybody?
Yes, sir.
So 341 basically stated the power lies with the parliament and the president in relation to SC list. But here in Andhra Pradesh Reservation Act, what it has done, based on the Ramachandra Raju Commission report, they subclassified that list. How do they subclassify? What can be done as subclassified? Suppose I am telling you regarding the Punjab, though it's a matter of just to show you the example. Suppose state of Andhra Pradesh did what? Though they might do it randomly, just to show you. This is A category. This is B category. C category. And D category. And 15% reservation of the SC, they bifurcated in 1%, 7%, 6%, and 1%. If Andhra Pradesh government did not do that, what will happen? Whole 39 categories, in this case the 57 categories are there, I am showing it for Punjab, don't get confused. So for whole 57 categories, 15% will be decided or kept. Any one caste or tribes who are eligible, who are good enough, they can get it within the domain of 15%. If the act was not passed. Are you understanding the problem? Are you understanding
Yes,
the
sir.
problem?
Yes, sir.
The moment it is subclassified, then 1 to 10, out of this all the categories of SCs, they can only get 1%. They can only get 7%, they can only get 6%, they can only get 1%. Out of this whole 15% reservation.
So before subclassification, all the categories were eligible to get 15%, but after subclassification, they would get
All the
1%.
eligible now, all the categories now, all the categories were clubbed together and classed as SC. Under that SC belt, anybody, suppose this 37 category who probably get or use 14% of that 15% can be done. No problem at all. if they're good enough, those particular people of those Sikri Band or Sirki Band, they're good enough, they can get the quota. Are you understanding, everybody?
Yes,
Are you
sir.
getting, Ronoja, are you getting it?
Sir, are these the list of surnames? That's why they are being.
It depends. It's not only the list, it's a list of caste, tribe, and the other any kind of, you can say it, okay, class or whatever. All the things are there in this thing.
Okay.
This is a list that is created and segregated as SC, ST, OBC, and those things are there under Indian Constitution. So you will say
So,
that
sir,
surname is one of the thing to understand. Okay. That whether he belongs to SC or ST. That doesn't mean surname, you might hide surname, Ronojoy. That doesn't mean that you don't belong to this caste.
so sir, taking the
Right.
example of Sirki Ban,
Taking the
Sirki Ban. So prior to this categorization, sub-classification categorization, Sirki Ban was able to get up to 15% reservation.
anything. Any people from this any category can get 15% reservation.
So that was valid, but this sub-classification which was done by Andhra Pradesh was not.
Andhra Pradesh, what they did, they saw, suppose group A, these 10 categories people, they are advantages. These are less advantageous group. They don't have, suppose they don't have the facilities, they don't have the electricity, they don't have the education. Suppose उस area में education नहीं है, where they are living. So they were given better reservation like 7%. These people are advantages. So suppose they are given only 1%. Are you people able to understand? Best, are we getting it?
Yes, sir.
Yes, sir.
Venkat? Simran? Sanmukha Priya? Rishabh? Rajat?
Sir, the list is combination of all the castes,
Yes.
SC, ST, and all other backward castes.
SC, ST, all backward class. Who was, what you
It
were
is
saying?
clubbed all in this list, all or other example. The list is combined with all the
No.
caste or
This list is for only SC. There is a other ST
Oh.
list, OBC list. All the
Okay.
separate list, all the separate categories of reservation are there.
okay, okay.
Okay.
Sir, sir, here, sir,
Yeah.
what was the deciding criteria, sir? This 7%, 6%?
Based
Like,
on the how forward they are in how basically they only comparison they do, okay, is that in relation to the forward class or the general class, how they have come across and how close they are.
but, sir, this scene can be arbitrary. Sir, this
No, this
classification
scene
can be
can be arbitrary. How? If without a Raju Ramachandran report that can be done by the state, it's an arbitrary. You set up a committee, you do the research, you took the survey, you gone to the field, you have seen the things, and then you said it, na? How can it be arbitrary? Understanding this, sir? The committee is because of this, okay, it's not arbitrary.
But sir, sometimes states matlab give sir preferences
Yeah.
to
That can be done. That can be done. We're not talking about arbitrary here. The arbitrary question is not there in this thing. What you are saying, I am understanding. Can the state do it? Absolutely. Suppose यहाँ पर ज्यादा population है, they for the vote bank they give a 7%. Can that be done? Yes, absolutely. Listen. So out of this whole 57 categories here for 39 categories, state government seen that hardly 1% population belongs to there, 1% there. The rest 98% of SC community belongs to this particular community BSC. इसको 7-6% दे दो इन लोग भाड़ में जाए. Can that be done? Yes. But here we are not talking about that. Getting it? So before subclassification, how was the reservation given wholly to SC? You belong to SC community. SC as a class, 15% can be taken by anybody. Any of the person from this caste tribe, irrespective of whatever or whoever you belong to, if you are good enough, though you belong to advantageous group, or suppose you have all the facilities, you can crack and get the SC. Utilize the SC certificate. Simple. Are you understanding? अंदर जा रहा है या नहीं जा रहा है? Guys, tell me. Because this is a very important part to understand. If you don't understand this, the rest of the things will not matter to you. Ronoja, did you get it?
Sir, can you please explain it again? Because
Which part? Tell me your question. Then I'll be able to understand what's your problem.
no, you are telling me that my question is regarding this, that who are the deserving candidates according to their merits, that they need to be classified as per as their caste and other things.
Who are the deserving candidate?
Sir, can you explain it? That my question is this, that who should get the reservation, because I am not able to understand this according to their education or economic needs or what, that they should get
As
benefited
per
from
the thing that I told you for the research, the Raju Ramachandran committee, they have seen it that how forward they are in comparison to, because the reservation is given to get marginalized, get them at par with the mainstream.
Okay.
That is the main reason of reservation. और कोई reservation का कोई reason नहीं है. If you are mainstream or if you're closer to mainstream, the reservation chances are getting smaller and smaller. Okay. So Ramachandra
just a
committee is
question.
basically focused on that thing only.
Okay, sir.
Okay. So for that, they might see into everything: education, social understanding, literacy rate, okay, economic condition, caste, superstitions, all those things, all the various factors, okay, they're going to see, and then they're going to put it. Achha. Did everybody understood? Did everybody any query? Any query regarding this?
No, sir.
Nothing? Acha. What about others? Others, सब कुछ समझ में आया या नहीं आया है? Vaishnavi, did you get it? Venkat, Sanmukha Priya, Rishabh, Rajat.
Sir, these
Second.
four categories percentages were adding up to 15%.
Here, in this case, adding up to 15%. Yes, absolutely.
Okay.
Here, in this case, how they divided it. That's all. Yesterday, I told you different situation. Here, in the EV Chinaya, that's a totally different situation altogether. Sir, this subclassification is like EWS general category? Not like that. I mean, it is a totally different thing. Here, you might say EWS is because of the poverty line. That was the understanding given in relation to that. But here, the simple understanding that is given is totally different. That is within the SC class itself, if there is any group which is better well off than the others, then the reservation might be misutilized by that particular group. So it's better reservation should be given to that particular person or that particular group who is not getting or who is marginalized right now. Usko de do. Getting it? Sanmukapriya, are you people able to understand? Because I'm not getting much response from you people regarding this. Are you people understanding, right? Or not understanding? Agar problem hai, batao, where you people are finding it difficult. Shall I move to next part? Give me yes.
Yes, sir.
Next part. Okay. Okay. Chalo, बहुत बढ़िया. Now, moment this part is there, okay. The subclass. 1 second. When the subclassification is done, here in this case, this is the situation. One of the problem they faced, they made this kind of classification. And when they made, the state of Andhra Pradesh made this kind of classification, basically they have seen 4 different kinds of, they have seen the 4 different kind of categories they created. And via that, the first problem they faced, under Article 341, state doesn't have any power. Yes or no, guys? Under Article 341, if you read it by your bare understanding, state doesn't have any power to create any kind of law. But what state has done, state of Andhra Pradesh, they bifurcated this list, created another 4 subgroups and made a law. Yes or no?
Yes.
Right? Achha. Second very important thing. Second very important thing is that though the state was saying we have done based on the report, and I was telling you yesterday in relation to this, those sub-classification might sound better well off. Practically and logically, it is very sound. That it is better to target those and give those people who are actually needing it. Yes or no? It's better. Suppose if it is true, these people are actually advantageous, they don't need reservation. And this particular group of people are actually need reservation. What do you think? It's not better to give them better or more reservation to this group of people rather than giving to these people? Isn't it a fair
Yes, sir.
understanding? Isn't it a fair understanding? All of you guys. Right?
Yes, sir.
So that's how, though it is logically sound, this whole concept of sub-classification, but the legality is one of the very important part that is very, very questionable. Okay. Now, as the question arises of legality, okay, in the E.V. Chinaiya Supreme Court, first, it stated that it is violative of Article 341. It is violative of Article 341 because state doesn't have any power to create any kind of law or any kind of sub-classification in regards to this. Okay. Having said that, Supreme Court stated and given one very important concept here, and that you have to understand. Okay. Supreme Court given a concept of homogeneous group. Okay. I'm going to write it down. Supreme Court in the 341, while declaring it is unconstitutional under article or violative of Article 341, Supreme Court stated by uttering homogeneous group. Sir, what do you mean by homogeneous? What's so interesting about homogeneous? Now, homogeneous group, reservation comes under which list? We're going to talk about list also. Okay, entry 25, entry 41, that also we're going to talk about. We're going to talk about. Okay? Yeah. But one of the very important part that you need to understand here, we are going to talk about the legislative competence. We are not talking about legislative competence now. First, we are talking about the whether it is valid of Article 341. So, Supreme Court said under Article 341, when the list is created by the president, that list, by amalgamating all the different castes and tribes, create a deemed legal fiction called ASC, SC group. And this SC group is a homogeneous group in itself. Try to understand. This list that is created by president here, in this case, all the you have seen, all are treated same, and they are called SC in general. SC in general means they are clubbed together as a category in itself. That's a classification that is done. That is SC classification. Okay. And when that SC classification is done, here one of the most important part that you need to understand, that within that homogeneous group, if state is trying to tinker with anything, there is all probability creating another different group, or that homogeneous SC class further tinkered with and becoming a heterogeneous one. And if it is tinkered with, that list is state making any kind of chopping and changing with that list, then that list, the ultimate SC, that the class is itself getting ruined by state tinkering. Are you people able to understand the homogeneous class that I'm talking?
I didn't get it. How homogeneous to heterogeneous it became? I
Yeah,
didn't
homogeneous.
understand, sir. So you said that homogeneous group further if a state tinkers with it, then it becomes a heterogeneous group. I didn't understand that part, how it becomes a heterogeneous group.
How it is
And
homogeneous, you
also,
did not understand, right?
yeah, but then you said
Yeah.
that they become heterogeneous. Yeah.
Anybody
Sir,
else? Please
sir,
repeat the one section.
Sir,
Guys,
here, sir, can you,
any other
sir,
question?
here,
Batao. Tell me your question.
sir, my question is, I don't have any questions, sir. I have a doubt, sir. Can you please repeat from the very first, from the very line you introduced this homogeneous group?
Which part you did not get? Tell me.
Sir, can you explain from the starting of this homogeneous group?
Homogeneous group. Okay. Achha. Anybody understood the concept? Homogeneous? Anybody understood the homogeneous concept?
Yes, sir.
Achha. Simran understood, Srija understood. Okay, ठीक है. Homogeneous. What do you understand by homogeneous? In basic, don't worry about the case law. What do you understand the meaning of the word?
Same.
Homogeneous means what?
Similar, same.
Google search bhi kar lo everybody. What do you understand by homogeneous?
The same thing, things in the same group.
Right? So, if you go to the homogeneous concept altogether, homogeneous means of same and similar kind, right? and they forming a group or class, homogeneous class itself, SC. How? Suppose look at, there are 39, this particular Punjab list that we were talking about, randomly just opened up. Here, this Dharmi, one caste or tribe, Balmiki, Chura, Vangi, Bengali, Barar. So here in all those groups, if you see it, suppose one group might be socially backward. One group probably educationally backward. One group probably think about socially, educationally both backward. One group probably, though it's a very uncommon thing, they are also socially, educationally, politically backward. Bazigar, wow, what a group. Bazigar also probably socially, economically, politically, they are backward. Though they are differently backward in their, as a caste, as a tribe, but when they are counted as a whole, they are counted as a SC category itself. Understanding, Sayok?
Yes, they are counted as a single homogeneous
As a
group.
similar. Though probably in this situation, probably not similar. There probably all the different tribes are there. All the tribes are in totally different way. They don't even know each other or anything, nothing. In similar situation, in not in similar situation in the means, they probably in different situation altogether, differently backward in different situation. But as a class, they are treated as one. There is C. Under Article 341, suppose, Sayok, don't get offended or don't take it. Suppose you being Gagra community, you will not say Gagra. You will say I'm a SC. Yes or no?
True, sir. Yes, sir.
Now here, Ronojoy might be from Sanhai community. Ronojoy, don't take it personally.
No
But
problem.
Ronojoy is saying, no, Ronojoy will not say Sanhai. Ronojoy will say, I'm SC. SC is the class that matters. Because under 341, that is the class that is created by amalgamating all these different categories and tribes and created a homogeneous, same level playing field. All the SC, though these people probably one is socially, educationally differently able, but they are given the 15% reservation in total as the same level playing field. Are you understanding what SC is trying to say? Supreme Court is trying to say, are you understanding now? Everybody? Rishabh, did you get it?
Yeah.
Sanmukha Priya, are you understanding this part? Sanmukha
Sir,
Priya,
you were also saying that this list by amalgamating, it was creating a deeming fiction that the SC is a homogeneous group. What is
yeah,
the what is the reference of this deeming fiction?
it's a deeming fiction. It's a fiction in itself. It's a list. Though there are 39 varieties kind of tribe, they were treated as a SC. That SC is a fiction. SC is a tag given to the tribe under Article 349, 341. Though they are not SC. They belong to that tribe. but belonging to that tribe is under the SC list. So SC is a legal fiction created under the 341, that homogeneous class of SC. Understanding, sir?
Yes, sir. They don't identify as SC, but they have to because it is creating a legal fiction.
Identify as SC?
They identify as a particular tribe, but not as SC. But since the deeming legal fiction is getting created, so they have to be identified
Yes,
as SC.
yes. Legal fiction is what? When we read the Henry Main, legal fiction is something the law is giving that entity or something image that is created by the law only. Right now?
Yes, sir. Yes, sir.
The fiction that is created by law. Everybody understanding the legal fiction? The fiction that is created by law. Suppose a different identity is created. Different class is created here, different class is altogether created. That is SC. Because to give them the reservation. Everybody understanding? 341 homogeneous class.
Sir, about that heterogeneous part, could you explain how homogeneous
Abhi
SC?
heterogeneous mat jao. Heterogeneous is a Davinder
Okay.
Singh concept.
Okay.
Heterogeneous, homogeneous is SC. Heterogeneous, when you are going to understand the Davinder Singh, then Davinder Singh stated totally opposite. Davinder Singh stated, no, it's not a homogeneous group, it's a heterogeneous group. We will learn that reasoning also. Then we'll be able to understand how the two very different judgment in one Supreme Court stated this list as a homogeneous class, and in another case it is called as heterogeneous class. Getting
So
it?
this homogeneous class is mentioned in E.V. Chennaiya.
E.V. Chennaiya.
Okay.
Everybody understanding? Guys,
Yes,
samajh
sir.
raha hai? Achha, okay. Rajat, are you understanding?
Yes, sir.
Venkat, Vaishnavi, Parvez. So Parvez joined late. I don't know whether he is able to catch up the things or not. Achha. Aisha also joined late. Anju also. I don't know whether you are able to understand the things. Anybody having any query? Simran, are you able to understand? समझ आया आपको? Parvez, okay, बहुत बढ़िया चलो. Is this the answer for the first issue? Yes, this is the answer for the first issue. Homogeneous group. Okay, homogeneous is the, and also the state doesn't have any power under Article 341. State doesn't have any power under Article 341. That you have seen. It's a very clear-cut situation. State doesn't have any power under the 341 itself. Okay. Getting it? Now, next very important part that Supreme Court stated in E.V. Chennaiya. In E.V. Chennaiya, Supreme Court stated, and when you saw the chart of sub-classification that I mentioned in the very beginning of the class, you have seen that sub-classification was agreed upon by the judges in Indra Sahani, that is 9-judge bench. Yes or no? Yes or no?
Yes, sir.
Sub-classification that was agreed by Indra Sahani in a 9-judge bench case. E.V. Chennaiya had to answer that because sub-classification was agreed by Indra Sahani in the 9-judge in 1992 itself. So in the E.V. Chennaiya, the next question came up sub-classification was pretty much agreed by Indra Sahni, then why not sub-classification is agreed here? Here in this case, Supreme Court stated again, that is agreed for the other backward class. Here we talking about the SC and ST. And for SC and ST, separate list is created under Article 341. Which state doesn't have any power at all to tinker with. So Indra Sahni, that power, or Indra Sahni, that arbiter that has been mentioned here in this case, that is totally sidelined by the Supreme Court here in the EV Chinaya. Okay. Understood?
Sir, can you repeat?
Acha. What I said, in the first, that particular list, you got to see the sub-classification history that Indra Sahni agreed sub-classification for the other backward class. That I was telling, right? So the same question was posed to the Supreme Court in EV Chinaya. Okay, why not sub-classification is agreed for the SC and ST also? And Supreme Court stated that sub-classification, first and foremost thing, Indra Sahni agreed for other backward class, and there is a reason for it. Because there is a high probability of creamy layer that might be existing for the other backward class. For SC/ST, being a homogeneous group, being a distressed group, being a disadvantageous group, there is no need to create a further sub-classification here. That's why they're clubbed as SC and ST. Because they're already most disadvantages. Getting it? Rishabh?
Yes, sir.
Asha, tell me, Asha.
So did the court say that SC and ST are at like a similar disadvantage, like they are at a homogeneous disadvantage, so they don't have to be sub-classified?
Tell me again. Tell me again.
So did the court say that SC and ST, they are grouped in that way because they can be considered a homogeneous class because they have such advantages, and they do not have to be classified, sub-classified again?
No. Why the sub-classification is to be done, Aisha?
So because they might be, different from each other.
There might be different.
They might be different, and they need different kind of they might be different from each other.
The different kind of what you said? What you said?
In a situation where sub-classification is required, so where they're different.
Achha, sub-classification is required. No, let me tell you, because you were not there in the last class, and that's why the question is coming up. Sub-classification is basically for one reason, within the class or within the reserved category itself, how can that resource or subsidy or the proper benefit should be given to the actual needy people. That's why sub-classification was the basic need. Understanding?
Yes, sir. Yes, sir.
Right?
Understood. Yes, sir.
So, in the other backward class, there's a high probability of creamy layer that is existing. So, in the Indra Sahni, other backward class, the sub-classification, it is already stated, and the creamy layer concept is also there in the Indra Sahni itself. But for SC/ST, in Indra Sahni, they basically believed SC/ST are the most advantageous one. उसमें सब कोई most advantageous है. Most disadvantageous one. So, all the people who belong to SC/ST, you don't need to further sub-classify them because all of them need the reservation.
Got it. This was
Getting
held in
it?
Indrasani. Yeah.
Yeah.
Okay, sir. Got it.
Okay. So this is the part what being followed in E.V. Chinaya also. E.V. Chinaya stated, first and foremost thing, state doesn't have any power to subclassify. So under Article 341, is state card, it is gone. Second, in case of if state has any power, okay, to create reservation, which I am going to talk about the 16.4 right now, okay, but that is for the other backward class or for the backward class. Okay, not for SC/ST.
So
Now
sir,
open,
here,
yeah.
here further subclassic, sir, further subclassification can be done for the OBC class.
Yes. That is there, that is proven. E.V. Chinaya is saying that is there for that. But for SC/ST, it was not. SC/ST, the sub-classification cannot be done. Sir, E.V. Chinaya overturned in the no. E.V. Chinaya cannot be overturned. E.V. Chinaya is not overturning anything. E.V. Chinaya agreeing to the sub-classification of the other. Here we are talking about the sub-classification of the SC/ST. Anju, we are not talking about the sub-classification of the other backward class. Okay.
So sir, we can say, sir, we can say that in sir E.V. Chinaya judgment, they agreed with the Indra Sawhney contention about,
because those who are talking about the other backward class, fine enough, no? It is talking about the other backward class. It's fine. Here we're going to talk about E.V. Chinaya. What we are talking about, the main, what is the legislation we are talking about here? Legislation name is what? Andhra Pradesh SC Act, right? Yes or no? So when it is for other backward class, it is for the other backward class. For SC, it's a totally different game altogether. That's what E.V. Chinaya Supreme Court is saying. Getting it, Rishabh?
yes sir.
Getting it. Now, next very important part, which Supreme Court, here in this case, Supreme Court has stated some very interesting things. Then the next very important part is the legislative competence, where the state have the power to create this act or pass this legislation. For this, go to entry 25 list 3 and go to entry 41 list 2. Go to entry 25 list 3. At the back end of your book, you will find the list, 3 different lists. List 1, list 2, list 3. Entry 25 of the list 3 and entry 41 of the list 2.
Sir, list 2 entry what?
List 2 entry 41 and the entry 25 the list 3. So what are these 2 lists? Anybody can type in the chat box. What are the 2 entries? Because state was claiming under these 2 entries, state have the legislative competence to come up with this AB Reservation Act. Sir, what are the major points made in Indrasani? I have already told Anju in the very first part of the class itself. Okay, आप जब recording देखोगे, you'll be able to understand. Okay.
So could you repeat the list numbers which you were saying?
Entry 41 in list 2, entry 25 of the list 3. Open it up, share in the chat box, anybody. मिला है ना? List 1, list 2, list 3. State was claiming state have the power to create this particular legislation. They have the legislative competence under these 2 entries. Okay. Entry 41 of the list 2, right? Entry 41 of the list 2, that is state PSC. Education. Education is one of the very controversial entry. Right? So you might be thinking, sir, do they have the claim under this entry 4125? How many of you are thinking? I mean, it's a valid claim that they have the legislative competence under these 2 entries. How many of you think they have the legislative competence or not?
Sir, I don't think so.
What you were thinking?
Sir, I don't think so. Sir, these 2 talk about education, including technical education, medical education, universities, and one talks about state public service commissions. How are they
Yeah.
related to giving reservation?
Now, here how they're connecting is they're connecting with the Article 15.4. Now read Article 15. समझ आया? अभी how you are understanding why the state is claiming that? State is saying under Article 15.4 and also the 16.4 is one of the very important thing. Via that, along with the entry number 41 of the list 2 probably, right? Entry 41 in the list 2 and entry 25 in the list 3. Yeah. The state has the power and the legislative competence to create the law or create this particular thing. Now, can anybody remember whenever the legislative competence of any particular legislation is called into question, what is the doctrine behind to check whether any particular state does have the power to create the law? Anybody under Article 245, 246, 247, there are so many doctrines that are there. Anybody can tell me what are the doctrine that has to be checked to understand whether legislative competence is there in the state or not? Anybody can remember? Anybody can remember? Not really? No problem. So under Article 245, 246, okay, 247, those things, under those articles, there are so many doctrines. Doctrine of territorial nexus, colorable legislation, pith and substance, repugnancy, residuary power. So many articles, so many doctrines and different things are there. Yes or no? In this 8 to 9 articles, so many different doctrines were there, right?
Yes, sir. Yes, sir.
Now, out of those things, Supreme Court utilized the doctrine of pith and substance here to understand the legislative competency. What is the doctrine of pith and substance? To actually go deeper into the act and find out what is the main purpose of the act, what is the pith and substance of the act, and alongside with what is the main purpose to come up with this legislation. Now, when Supreme Court entered into this particular act of this when I was talking about AP Reservation Act 2000 of Andhra Pradesh, Ibichinayas, when they saw it, they only found one substantive provision, that is section 3, and all the provision is the procedural provision, how to get it. What that substantive provision basically talks about is that all the bifurcation A, B, C, D that I showed to you, the 1%, 7%, 6%, 1%, that the different sub-classification of reservation that has to be given to these groups, and the rest all the provision in the act talking about how to avail that, or what is the process of it. So when Supreme Court entered into checking the pith and substance of this AP Reservation Act, they said this particular legislation is all about sub-classification, and there is no connection with entry number 41 and 25 to far extent, not in relation to Article 15.4 and also 16.4. What is related? It is related to sub-classification, which is absolutely not under the purview or power of the state under Article 341. Getting it? Understanding?
Yes, sir.
Pith and substance doctrine, everybody understood how Supreme Court stated? Any query? Ask me. Achha. Repeat. What about others? What about others? What about others? Repeat. Okay. To check the pith and substance, we need to go into a legislation to find out the main purpose and substance of that particular legislation, and whether that substance is in any way connected with the entry 25 and 41. Understanding, guys? Is this to check the pith and substance? Is this the thing? If the actual substance of the legislation or the purpose of the legislation anyway connected to the entries that are mentioned by the state, that is 25 and 41. If that is connected, then the state has the legislative competency. If it is not, then state does not have. Yes or no? Clear? Now, when the
Yes.
Supreme Court checked into the pith and substance of this particular legislation of AP Reservation 2000 Act, in that Supreme Court found out that this particular legislation is all about sub-classification. There is only one substantive provision, that is section 3, which basically bifurcates all the 57 categories into 4 subcategories, that is A, B, C, D, giving them 1%, 7%, 6%, and 1% respectively. And the rest of the provisions are talking about the procedural aspect to it, which is nowhere related to the entity number 41 and 25 in whatsoever, or even Article 15.4 and 16.4 whatsoever. So what state has basically done, via this act, state has already created the bifurcation or the sub-classification of the legislation or the SC list, which is absolutely prohibited under Article 341. Getting it?
Sir,
Yeah.
how is it not related to 16.4 or 15.4?
Sorry.
How is it not related to 16.4 and 15.4? They are making up that.
How it is not related to 15.4, 16.4? It is 15.4. What it is talking about? 15.4, it's talking about the
special
socially
provision for
educationally backward
class.
class, right?
Yes.
Right. So state has been given power in relation to reserving or reservation reservation in relation to socially educationally backward class. The Supreme Court is basically seeing nothing mentioned about the sub-classification. Sub-classification is the domain of Article 341 or the list, that is 341. What state has tried to encroach into. Understanding, Simran?
So can't we say that sub-classification is a special provision under this 15.4 or 16.4?
Because that time in the E.V. Chinaya, Supreme Court didn't see that way. In the E.V. Chinaya, Supreme Court saw that the sub-classification is tinkering with the Article 341 itself.
Because it's
And
a
Article
more-
15.4 and 16.4 majorly talking about the socially and educationally backward class or the backward class as such. Doesn't talk about the SCs and STs.
Okay, sir.
Understanding?
Yes, sir.
Now, what they're trying to do, Supreme Court, the socially educationally backward class, along with the other backward class in the 16, it is there. They interpreted that backward class with Indra Sahni's backward class. How they're connecting.
Sir, what is the entry 25 and 41 that you are referring?
What is the
Sir, entry 25 and 41 that you have referred 2 times.
entry 25 and 41? It is there in the देखो chat में दिया हुआ है. Entry 41 is the state PSC and the entry 25 is the education.
Okay, sir.
Understanding, guys?
So they equated OBCs with the socially and educationally backward class to separate it
Yes.
from SC. Okay.
So they thought and they believed that the SC ST 15.4, 16.4 doesn't talk about much about SC ST. That the backward class that is mentioned is more about the backward class that we are talking. And in Indra Sahni, that backward class is mentioned in which sub-classification is done. That's not the case all about. This case is all about the SC's backward sub-classification. Getting it? Are you people able to understand?
So they're basically saying that the power under 15.4 and 16.4 is related to OBCs and not ST and STs.
What E.V. Chinaya is saying, 15.4 and 16.4 doesn't really give the power to sub-classify, first and foremost thing. It will create law for the reservation. In that case, basically how that 15.4, 16.4 power is there, suppose SC list is created, right? And under the SC list, they will have a law, and in that law, suppose 15% or 25% reservation or whatever, suppose 21% reservation is given to that particular caste. This is a law. Understanding, Simran? How they're interpreting
Yes, sir.
15.4, 16.4 basically given the power to state, but the power is to make law in relation to reservation, true. But doesn't really give the power to sub-classify within the list of 341. It gives the power to create a law for reservation. The list is along with the list which is already mentioned in the Article 341. Getting it?
Yes, sir.
Understanding?
Yes, sir. Got it.
Okay. So how they're getting into it? They are basically getting into this thing in this way that the state has been given power under 15.4, 16.4, but that power is bit different. That is not related to sub-classification of the list. That is, suppose इस particular SC को इतना reservation देना है, ठीक है? Or in different, in education, in public employment, this kind of, for this group, for SC, this kind of reservation to be given, for ST, this reservation to be given, OBCs as a reservation jayega. And for that, different list is going to be created. Sorry, different laws to be created, or one law may sub kuch different is it will be amalgamated and separate laws will be created. But not to tinker with the list that is already provided by the president. After given the precedent list, they will have to act on that list. That's how the 15/4/16/4 power is divided. So the power under 15/4/16/4 is to be used state only for the making provision for the reservation for the groups and the list created under Article 41. Yes. That's how they basically tried to construe the Article 341 with the 15/4 and 16/4. Understanding? Srija, Sayok, Ronojoy, probably for your first class, it might be a bit difficult for you to understand, but are you able to
Little bit
understand, Ronojoy?
Yeah, I can grasp some
Okay.
of it, sir.
Okay. So last class I was talking about a lot of things. So do check the last class, you'll be able to understand better. Okay.
Okay, sir.
Achha. Pranjali, anything has got into your head regarding this? Vaishnavi,
Yes, sir, almost all.
almost all. Okay. Vaishnavi,
Yes, sir.
Srija, not got it.
Yes, sir, got it. No problem.
Rishabh,
Yes, sir.
देखो झूठ बोलोगे तो पकड़े जाओगे नेक्स्ट क्लास में जब दविंदर सिंह पढ़ाए, क्योंकि दविंदर सिंह विल बी टोटली ऑपोजिट टू दीज थिंग्स.
नहीं सर, आ गया सर.
Okay. Rajat, getting it?
Yes, sir, getting it.
Sayok?
Yes, sir. Yes, sir.
अच्छा, ओके, बहुत बढ़िया, बहुत बढ़िया. वेंकट?
Yes, sir.
So by seeing all the things and putting 341 as the higher pedestal and the interpretation of the 15/4/16/4 along with the 341, they basically stated the sub-classification that what has been done here in this case in the EV Chinaya is absolutely wrong and it is invalid. And they set aside the sub-classification for the very first time.
Sir, even if let's say the SC category, SC group, within the SC group, this categorization of A, B, C, D wasn't done, and there were certain tribes given certain provisions for reservation. So that will still be falling under sub-classification.
Yeah, that you were saying the ABCD will that coming under sub-classification or not, right?
No. I'm saying that if this ABCD categorization was not done, and in the SC group, this let's say this top
Given
10
15%.
people were.
No, that's a no. How can this be sub-classification then?
So
SC as a
basically,
class, homogeneous class given 15%. That what SC is saying. Supreme Court is saying SC is already a homogeneous class under Article 341. And you have to give that 341 list respect and you have to give the reservation accordingly.
So if I don't create categorization within that SC list and I give reservation to a particular tribe, let's say these top 10 tribes of SC list, so that will fall under sub-classification. That is my doubt.
No, that will not. That will be another sub-classification. Now you are focusing. Now that's the beauty of homogeneous class. Na? Homogeneous class has to be treated homogeneous. Homogeneity has to be maintained. The moment
Is
you
all-
cherry pick one
all
and
of
give
them have to
more,
be made.
the
Okay.
homogeneity of SC will be disturbed. The legal fiction is disturbed now.
So all have to be treated as SCs so as to give reservation.
Exactly. That what in the Davinder Singh, the Punjab Haryana court, with the how that case, in that case, what basically happened in Punjab, Balmiki's and what is there another one? Mazhabi or this particular group. I think so, yes. In Punjab, because that was Balmiki and this particular group, Mazhabi or something like this. These particular two categories were given half of the SC's reservation. And Punjab Haryana High Court basically struck down that particular Punjab Haryana Reservation Act by quoting E.V. Chinaiya. That happened in 2010. That is the Davinder Singh Punjab Haryana High Court judgment.
So Punjab didn't create subcategorizations of A, B, C, D. Instead, they just targeted Valmiki and Madhabi and did
Exactly.
the
Balmaki and Mazhabi or something like this. यहाँ पर Punjab का ही है. I don't know exactly the particular ये. Okay. That
So
particular
that
two
was my
group.
doubt. So if
That is a
targeting these two groups,
subcategorization. That is subcategorization and subclassification itself.
okay,
E.V.
that is
Chinaiya
something which is
stated
not allowed.
it has to be
Okay.
treated homogeneity. Homogeneity is to be maintained as per E.V. Chinaiya. You can't really cherry pick any one tribe or caste out of the SC class and give them the more reservation. The moment you do
Okay.
that, you are cherry picking and tinker with the list of Article 341, which you don't have the power. Understanding, everybody?
Yes, sir.
बोलो जितना yes करोगे दाविंदर सिंह तो पढ़ेंगे. Davinder Singh में all the things were said opposite. All the things. Davinder Singh will say it's a homogeneous knot. It's not homogeneous, it's heterogeneous. Davinder Singh will say it's a Indra Sahni has already stated it, the backward class, and backward class includes SC, ST, OBC. Hello?
Sir, it means that Davinder Singh 2010 case followed the E.V. Chinaiya, but the
No, no,
2024 case.
That the Punjab Haryana court. That is Davinder Singh was state of Punjab. I written it two things. You didn't follow it. I written Davinder Singh was state of Punjab. This Punjab Haryana High Court case. There is state of Punjab as Davinder Singh. Okay, that is a 2025 judge bench, and another state of Punjab as Davinder Singh. There is 7 judge bench. That is 2024. There are 3 cases of Davinder Singh state of Punjab.
Yes, sir. Yes, sir. I
One is
thought
Davinder Singh
all
was state
of
of
them
Punjab,
are
and 2
quite.
is state of Punjab as Davinder Singh.
Yes, sir. Yes, sir.
Okay. All the reasoning given by E.V. Chinaiya are totally opposite Davinder Singh. और आप सुन के हैरान हो जाओगे. All the things are opposite totally. Polar opposite. I haven't found any polar opposite reasoning to any case. The first case I have seen where the polar opposite reasoning. Because heterogeneous has to be homogeneous. Backward class के अंदर everybody is there coming under the backward class. Where the substantive equality, that doctrine that I was talking to you people. याद आ रहा है? Class में I was talking about. In the first
Yes,
class.
sir. Yes, sir. Yes, sir.
They picked that and they put it the backward class of substantive equality. They will explain. That's why I told you. Probably it's a second class, but I told most of the things. E.V. Chinaiya, I told you. And one of the very major concepts in E.V. Chinaiya is homogeneity. Yeah, tell me. Come, Sahib.
So this backward class includes SC, ST. This was given in which case?
You will get to see. That is Davinder Singh Nayak.
Okay.
The
Because
Article
if the
16 for
constitution,
backward class includes SC, ST, OBC.
But if constitution segregates between SC, ST and backward class, then how can they say that they include? Then why did they mention SC, ST separately?
anything. वही मैं बोल रहा हूँ, आप देखोगे तब पता चलेगा आपको. In 16.4, the backward class they mentioned that 16.4 backward class has wider ambit than the 15.4 socially and educationally backward class. Acha, everybody understood? Everybody understood?
Yes, sir.
And another very, very beautiful thing that Davinder Singh state have the power to tinker with the state law. Totally opposite. State have the power to tinker with the state, that list. Whatever you learned, totally opposite you're going to learn. Totally opposite. That's why it is basically overruled. You'll get to know that. But so far, did you understand in the two classes? Did you get the base? And also I told you the EV Chinaya, because this is the most important part, the article 341 and the homogeneity concept. Everybody understood. Ye concept dono chahiye. And state doesn't have the power. Ye three things that I want all of you to take from this case, because these three things will be needed to be challenged in the Davinder Singh. Only person who's happy in this class is you right now. Not really. I hope you are also understanding the things. That's great comment. So EV Chinaya and how the classification, sub-classification history, everybody understood. Everybody understood that part. कल के क्लास में जो classification to this part that I told you, today in the very initial part I talked about the sub-classification history, and now I talked to you about the EV Chinaya. All of you got the things or any query that you have? ऋषभ 500 पेज के जजमेंट पढ़ रहे हो, कैसा लग रहा है आपको, बताओ.
Very happy, sir.
Very well.
Sir, if you see, DY Chandrachud only gave around 100 to 125 page का judgment. बाकी सब तो conquering opinion.
Yeah, confident. We'll see that. That's not a problem. But most of the things I have, so I just want to reading judgments in general, not this case. Yeah, tell me, Simran. Tell me. I want to ask about reading judgments. Yeah, tell me.
Sir, so in a judgment, a lot of reference cases are mentioned. So how do we pick which case to focus on? Because there
Which
are
case they're referring?
questions
Which case
on,
they're referring to be, when deciding the things, which case they're referring in the ratio itself?
but there are a lot of judgments that they
That's
refer
the thing.
to. Like,
In that case, you have to understand which case actually making the ratio of this case. That you have
how
to
to,
decide and you have to understand. Those cases are going to be important.
how to do
Understanding,
that?
Simran?
Yes,
Okay.
sir.
10 different reference cases are there. Out of those 10 reference cases, probably hardly one or two are actually making the ratio of this current case. Those cases to be read, not the other 8 cases.
Okay, sir.
Okay.
Sir, in EV Chennai, the third issue you didn't say that subclassification is violative of Article 14. How?
Tell me.
So the third issue of EV Chennai, you didn't dealt with. That was about whether subclassification is violative of Article 14 or not.
Yeah, third year. Third year is not related to our concept, so that's why I don't get into it. Okay. So basically, third is also related. Third is also related to the Article 341. Okay. How? Because the one class is already created. SC, ST, OBC, the three classes are already created. Okay. Now, when that particular class is created and creating a class within that class and giving them the thing, though that class has to be treated differently, is a violative of Article 14. What I mean to say is that, one second. Being a part of homogeneity, SC has to be treated as a class, right? Whole 39 is to be treated as SC, right? So,
Yes, sir.
now when whole 39 is to be treated to be SC, okay. Now suppose in the class itself, okay, in the class itself, suppose मैं मान लेता हूं, all, how many people are there? 13 people, 12 people are there. In the 12 people, all the 8 hard copy books to be sent. That is the norm. That is the equality. 8 books. Okay. Suppose I'm giving you 5 books. 5 books is a norm that has to be sent. But the thing that you have to understand now, if I'm going to cherry pick, suppose I cherry pick Sayok and Venkat out of these, all the 12 people, and I send 15 books for them. Is it violative of Article 14?
Yes, sir.
Understanding? It is because it is coming, all the things are coming from the homogeneity. Okay, Acha. Yes, sir. Referred cases questions are difficult. Yes, it is difficult to memorize all of them because of the questions are unpredictable. Yes, Vaishnavi, dekho, one of the things that you need to understand, there are some referred cases questions that definitely be there. Okay. Don't think too much about the referred cases, otherwise it's not directly linked with this particular case. Suppose how in Davinder Singh case, one of the referred cases, EV Chinaiya, Indra Sahni. Okay. Even some part of the journal Singh you might find, because in journal Singh creamier concept first came, and then in relation to that might lead to subclassification. These cases have to be read, understood in parlance to this thing. But suppose any random question asked Western or Simran, and you will find, okay, you will find some random cases asked from this question. Don't bother about those things. If you start bothering those cases and bother about these questions, then that will be very, very problematic for your understanding. That will derail your preparation altogether. This is a part of unpredictability that you have to keep it open. Those things will come, you will not be able to answer, or it's a very good day for yours, whatever you read that's asked and you are going to answer. Getting it? That doesn't mean I'm not saying whatever is directly interlinked and some cases which are being overruled. In Sita Soren, PV Narasimha Rao, you have to understand. Understanding, Vaishnavi? Up some other cases are getting asked, then sometimes it's not in your hand. There are some most important cases, and I told in the very first class of the case laws, okay, there are some most important case laws which you need to go through again and again, which is very important, might be asked in the exam. Did I tell you? Did I tell you that? Anybody can remember? So for most important case laws, if you have the time, do read thoroughly as possible, but only for those 5, 6, 7, 8 case laws only, or 10 case laws only, not for 60, 70 or all the case laws that you will get in 2024. Understanding? If those case laws which are highly important, like electoral bond ho gaya, like Davinder Singh ho gaya, Article 370 ho gaya, these cases are highly important. For this, you might read it again, you will read it again, and you will find out that some portion I'll find it easy and I'll be able to understand. Okay, for 4, 5, 6, 7, hardly 10 to 12 cases, you can do that, you will do that. But that is not possible for every case law. You will find any company law case law which is not important. Do you need to do that? No, not really. Getting it? Did I answer your query, Simran and Vaishnavi? Okay. And even those 12 very important case laws, because all are for 300, 500 pages, you might miss something. It is bound to happen. You might. And it's absolutely accept that. I read 5 times, I didn't get it. Absolutely fine. Fine enough. But you have to put the effort also. I'm not telling you don't put the effort to understand the case law. For those 12, 15 case laws that you have to read. You have to read very, very thoroughly. Because वहां से क्वेश्चंस आएंगे, वहां से आपको आंसर करना है.
Sir, sir, have you given any list of the important cases till now?
As of now, the list will be given. Coming month, the list will be there. ठीक है. So not a problem. So अभी तक कोई list नहीं किया है, तो list तो compile हो रहा है. List will be given to all of you. Not a problem. And another thing I will tell you, there is one very important PDF, and I'm telling you a bit early. I would have told you after 2 months. Generally, in each and every batch I tell after 2 months, not now in the month of September, October I tell it. I'm telling it now in August. There is a under the case book folder, there's a PDF of law exam notes. You'll find that. Under the case book folder, there is a particular document called law exam notes. Okay. Do follow that. Because those are highly important events or related to cases or the national phenomena or international phenomena that were described in 4, 5, 6 pages, 7 pages. Okay. Though that is not needed right now, or it will be done for this year also. But for the last 4 or 5 years, the law exam notes PDF are there. If you go through that, you'll be able to understand what are the important topics of various subjects under that law exam notes PDF. You'll be able to understand. आपका बहुत काम आसान हो जाएगा उससे. ठीक है? Did you get it? Under the casebook folder, you will find it. Did everybody got it? Any query? Yes, we will. Sanmukha Priya, we will. शेख हसीना नहीं पढ़ोगे? सन्मुखा? Not read शेख हसीना? Definitely, शेख हसीना. Sheikh Hasina has to be read, huh? It's very important. Israel Palestine case too. So there are. Any other query, guys? Any other? Did you understand? Are you understanding the case laws? Are you understanding the case law? Everybody give me a yes. Or not able to understand, it's fine. Just have a reading of it, whatever I have talked about in the last 2 class. Recording देखो. Next हम लोग Monday को तो नहीं, next Thursday we'll talk about it. Okay. Send the PDF of this EV Chinaya. EV Chinaya search करो ना, EV Chinaya का PDF where I was reading it from. Oh, I was reading from probably live log. Davinder Singh, yes, I will. Don't worry. Okay, chalo. Good night to all of you. See you again on Monday. Thank you, all of you.